Hello, everyone, and welcome to Law and Democracy, a podcast of the Election Law Program at The Ohio State University Moritz College of Law. I am Tony Gaughan, Professor of Law and the current Family Chair in Law at Drake University Law School. I'm also a Senior Fellow in Ohio State's Election Law Program. I'm joined today by Professor Steve Huefner, the C. William O'Neill Professor in Law and Judicial Administration at The Ohio State University Moritz College of Law. Steve is also the director of the Legislation Clinic and the deputy director of the Election Law Program at Ohio State. We're also joined by Professor Terri Enns, the James W. Shaughnessy Professor of Law at Moritz. Terri is also a senior fellow in the Ohio State Election Law Program. Our guest today is Professor Kerrel Murray, an associate professor of law and the Milton Handler Fellow at Columbia Law School, which I might add is Steve's alma mater. Kerrel teaches and writes about constitutional law with a particular interest in Reconstruction, election law, and race in the law, among other topics. His scholarship interrogates what democracy demands of our legal rules and institutions, as well as the role of law in mediating conflict and disagreement. In 2023, he was named the Yale Law Journal's Emerging Scholar of the Year. Before joining Columbia Law School in 2021, he completed a 2-year fellowship as a postdoc research associate at the University of North Carolina School of Law. Prior to that, Professor Murray served as a fellow at the NAACP Legal Defense and Education Fund, where he co-authored amicus briefs in the U.S. Supreme Court and multiple state courts. He was also an associate in Covington and Burling's Washington, D.C. office, where he focused on complex civil litigation. He clerked for then Judge Ketanji Brown Jackson on the U.S. District Court for the District of Columbia, for Judge Timothy Temkovich on the U.S. Court of Appeals for the 10th Circuit, and then again for Ketanji Brown Jackson in her first term as a justice on the United States Supreme Court. Well, welcome, Kerrel. It's a pleasure to get to interview you. Our topic today is the pending U.S. Supreme Court case of Louisiana v. Callais, in which the justices are faced with the question of whether Louisiana's creation of a second majority-minority congressional district violated the 14th and 15th Amendments. Professor Murray has written an important and fascinating amicus brief in the case. Before we get into the details of your argument, Kerrel, perhaps we could begin with a big picture question, which is simply this: what prompted you to write the amicus brief?
Great. Well, thank you so much, Tony and Terri and Steve, for the invitation. And really excited to be here, a long-time listener to the podcast. I was frankly prompted to write the amicus brief because of a long-term interest I've had in Section 2's design and the best way to talk about it. I had, for a long time, as I taught election law, thought about the best way to describe Section 2 to my students. You know, especially the first time you teach a class, you sort of try to really dig into the guts of a particular doctrine to understand what you can relate a doctrine to for the students. So my initial reaction when I first encountered Section 2 as a teacher was to assimilate it to the disparate impact framework. But as I dug into its history and its text and its context, I became a little bit less sure that that was the best phrase to use to describe it. So I actually had long wanted to write an article exploring that, seeing if I could defend it, seeing if I could explain, well, if it's not a disparate impact statute, what kind of statute is it? And I suppose I should say a little bit about why somebody might think Section 2 is a disparate impact statute. Makes some sense since I just jumped into describing it. So that would require a really brief summary of what Section 2 is, and I'll try to not have this answer go on too long. But the Section 2 that we're interested in is Section 2 of the Voting Rights Act. And as it stands today, it comes out of a 1982 amendment to the 1965 Voting Rights Act. Now, as initially enacted, the Voting Rights Act did have a Section 2. There's some dispute, which I guess we could talk about, as to what that original version was meant to do. For our purposes, I think what matters is that in 1980, a plurality of the Supreme Court, in a case called Bolden, held two things. Number one, that the 15th Amendment itself requires that a plaintiff show discriminatory purpose by a defendant in order to succeed in a voting rights challenge. And it also held, the plurality did, that the original version of Section 2 did nothing more than the 15th Amendment itself. So the upshot was that Section 2, as the plurality saw it, required discriminatory purpose. And your listeners may be familiar with cases like Washington v. Davis or Personal Administrator v. Feeney. It's essentially importing the reasoning of those cases into the election law arena. So it just so happened that in 1982, the preclearance provisions of the Voting Rights Act were up for reauthorization. And so Congress took that opportunity to attempt to repudiate the reasoning of the Bolden decision. And it's generally agreed. There are some things we could talk about that people dispute about this, but what people do generally agree is that Congress was attempting to repudiate the Bolden decision. It was attempting to say, no, we don't want a plaintiff to have to show that the creator of, let's say, a districting map acted with discriminatory purpose. Now, that all matters to where I started, because one plausible take you might have from knowing that Congress is trying to repudiate a discriminatory purpose rule is that Congress has created a disparate impact. When we teach cases like Washington v. Davis, you sort of say, well, Washington v. Davis was the court refusing to import the disparate impact rule of Griggs into the 14th Amendment. So it would make sense, sort of in a vacuum, to say, well, Congress is simply doing that, but for election law. But I think that once you dig into the history and text and context of Section 2, it's not quite that simple. And that was the purpose, explicating that point, was the purpose of the underlying article that I wrote, just coming out in the Fordham Law Review this year, and the amicus brief, which was based on that article. And I'm happy to talk more about that, but I know I've been talking for a while. But the short answer is that I wanted to write this brief to communicate to the court a account of Section 2 that I think could be valuable, and which I think is not always put before them in a way that is helpful. I guess the last thing I'll say is that it's particularly helpful, I believe, because the more that the justices see Section 2 as heartland disparate impact, the more likely, arguably, they would be to think about it as problematic under the colorblind constitutionalism framework that animates cases like students with fair admissions. So I do think providing what I think is a correct alternative frame could be quite important as the court considers aspects of Section 2's constitutionality in the Callais case that you mentioned.
Kerrel, as you've just summarized some of your own thinking here, in juxtaposition to what would be a more routine disparate impact way of understanding Section 2, I found myself just wanting to get your sense of how distinctive that is. And maybe another way of framing that question for you is, it seems to me that the kind of prototypical disparate impact way of thinking about the amended Section 2 is the way in which it has largely been talked about. And is that your sense too, that that's really just how we default into thinking about amended Section 2?
Well, I don't want to. I think the short answer is that probably is the default for many people. I don't want to suggest that nobody's ever sort of recognized that. Let me say a few things about that. So the reason I think the disparate impact label is probably not apt, one important reason, is that we know that Congress was relying on certain cases that the Supreme Court issued before the Bolden decision. In those cases are Whitcomb, 1971, Register in 1973. In those cases, the Supreme Court analyzed a racial vote dilution claim of the sort that is often brought under Section 2 today. But in those cases, the Supreme Court took pains to say, by the way, the potential claim that we are evaluating here and that the court, in fact, embraced in the Register decision, that claim is not a claim based on a lack of electoral proportionality. In other words, it's not a claim based on a particular racial group having some sort of constitutional entitlement to control X percent of seats because it is X percent of the population. So that's a point that people have long recognized, that those cases were something that Congress incorporated. And so to that extent, I think the idea that Section 2 is not necessarily doing something, that is pegged to population proportions in the way that classic disparate impact is often thought about doing, that idea has been thought of, number one. And I think that there are cases where the court has, in passing, sort of said, this statute is not a pure disparate impact statute in the way that you are perhaps most familiar with. But what I do think is novel, especially to the degree that's explicated in the article and amicus brief, is emphasizing the degree to which the proper frame, the affirmatively correct frame, is a disparate treatment frame. So what I argue in the article and then defend in the brief is that the best way to understand Section 2 is as a disparate treatment statute, insofar as it's targeting present-day effects of past and present intentional discrimination. Now, there certainly could be some conceptual overlap. You could see, and not just could, one justification for disparate impact statutes could be that they are interested in smoking out intentional discrimination. So I'm not claiming that there is hermetic separation here, but I do think that it is helpful and important to see how Section 2 is very much laser focused on the different ways in which intentional discrimination can reverberate throughout a political system. And as a result of that focus, it is focused on whether and to what extent current day actions by state actors are essentially incorporating the effects of intentional discrimination so as to result in disparate opportunities for voters today. And that's just, the reasons I get into more in the article and the brief. I think that framing offers some important distinctions that are important for thinking about the ways in which Section 2 is compatible or not with colorblind constitutionalism. So, short answer to your question is I do think it is often a default position that people take to sort of say, well, this isn't discriminatory purpose, therefore it must be disparate impact. I understand why they would say that. I think that there is a more nuanced way to describe what it's doing, in part because of the prehistory, the cases that were incorporated, in part because of the way that the statute was understood at the time of its amendment. And I sort of get into that in the article when I look at the media coverage and the way in which important legislative history talks about it. So I think that is a driving force for my preferred framing.
Kerrel, could you, assuming that some of our listeners are not as familiar with the whole context that we're talking about this in, can you situate what you've been talking about within the Callais case? Like how does your argument in your brief impact Callais, and maybe a little bit of what Callais is about?
Sure. So Callais is it's a quite complicated case procedurally. So just to say a few things about it. So Callais itself is a case that's currently pending before the Supreme Court. So in the case before the Supreme Court, the plaintiffs are bringing a claim based in an older case called Shaw v. Reno. Shaw v. Reno there's some complications, but it's essentially the court's importation of colorblind constitutionalism into the election law arena. So the plaintiffs there are sort of using the Shaw v. Reno doctrine. Now, the reason Callais is complicated is because the plaintiffs in Callais are attacking a map that the state of Louisiana drew after a different set of plaintiffs in a different case brought a Section 2 lawsuit and won a preliminary injunction in that separate lawsuit. After those plaintiffs in that separate lawsuit won that preliminary injunction, the state of Louisiana decided, we'll just draw a new map and we'll add a second majority-minority district. And it's that new map that is being challenged in the Louisiana v. Callais case. So I don't know that procedural history is directly relevant to the intervention that I'm making, except insofar as a Shaw v. Reno claim, as is being brought in the Callais case, often ends up raising questions of Section 2's reach and scope, because one reason, historically, and the court has, quote unquote, assumed to be the case, one reason one might be able to defeat a Shaw v. Reno claim is to say Section 2 made us draw this map. So Shaw v. Reno claims often implicate whether and to what extent there is a valid underlying Section 2 claim. So that's the context of the Callais case. That case is actually argued not this term, but the previous term. So the term that ended in summer 2025. But the court did not issue a decision in that term, and instead they set the case for re-argument, which has often been a precursor to significant decisions. So, for example, the Citizens United case came out of a re-argument order, and number one. And number two, in the re-argument order, the court directed the parties to address, as I believe Tony said at the outset, whether and to what extent that new map that Louisiana drew, the one with the additional majority-minority district, violated the 14th or 15th Amendments to the United States Constitution. So that question, and the court cited certain pages in the challengers' briefs, and in those pages, the challengers were essentially saying the students with fair admissions case should control here, and for the reasons based in colorblind constitutionalism articulated in the students with fair admissions, we should win. And the court said, take a look at those pages and tell us what you think, essentially. So that particular prompt is the prompt that led me to write my amicus brief, which is very much focused on, to the extent that you think there are questions about colorblindness here, it's important to recognize, and I didn't say it quite this way, but it's important to recognize that this is not the students with fair admissions case. You could think students with fair admissions is correctly decided and still think that Louisiana v. Callais should come out a different way. Section 2 operates differently than the admissions plans in that case. And it is in pursuit of a different interest than the admissions plans in those cases. And that's one reason why the frame of Section 2 as a disparate treatment statute that's targeting intentional discrimination's effects is important because, as your listeners may know, due to the development of the admissions cases, the admissions plans in the Students with Fair Admissions case were not, really couldn't have been defended on the ground that the universities are trying to remedy past or present intentional discrimination. Those plans were defended on the basis of diversity. And so just that alone takes us into a different landscape. So that's the basic background of the Callais case, and that's why I was interested. I probably should say just a little bit, because I mentioned majority-minority districts a couple of times. Let me just say really quickly, hopefully, what I mean by that. So essentially, a majority-minority district, you have a plan, let's say a congressional plan. Let's say a state has 6 Congress people. There'll be 6 districts. The districts each have 1 member. A majority-minority district is essentially a district that is drawn so as to have a numerical majority of a minority group, generally a non-white group. One reason these districts can matter is that they can be, although it's important to note they need not be, they can be remedies for Section 2 violations. So if a Section 2 violation is found, it might be the case, and in fairness, it often has been the case, that the way to cure that violation is to require the state to draw another majority-minority district. But it's important to recognize, and I make this point in the article, that you can cure a Section 2 violation in a variety of ways. Nothing in the statute requires that a majority-minority district be drawn. What the statute requires is equal opportunity for all people, irrespective of race. And it is possible, and it has happened, including in the remand from the Allen v. Milligan case, it is possible to cure a Section 2 violation without drawing a second majority-minority district. And that's important because one of the mantras of colorblind constitutionalism is that we want to avoid rigid, unthinking use of race. And often there's a sort of idea that Section 2 is running rampant and requiring, hard-edged, rigid majority-minority districts throughout the country. In reality, that's not the case. In reality, you can cure the violation in a variety of ways. I know that last part wasn't really part of your question, but since I had mentioned majority-minority district, I thought I would get into it.
On that very point, Kerrel, perhaps could you discuss why the word proportionality basically serves like a third rail of gerrymandering or politically or racially motivated redistricting in the view of the Supreme Court? And one interesting fact I think our listeners might not know about Louisiana, you just made reference to the fact that Louisiana has 6 congressional districts. And so we're talking about going from 1 majority-minority district to 2. Louisiana's population is about roughly 55% white. So it has one of the smaller white populations of any state in the United States. And it's about 33% African-American. So going to 2 majority-minority districts just reflects the demographics of the state. So for a lot of listeners, I think that would seem uncontroversial. But because of the court's view of proportionality, obviously it makes the map suspect. So perhaps you could just provide some background on why proportionality is so controversial in the minds of many justices.
Great. And just to, I'm assuming you're right to say Louisiana has 6 congressional districts. I didn't have that in mind. So if it doesn't, then don't quote me on that. I know it has somewhere around there. But to answer your question, so there are a few, 2 important points one could make about proportionality in the context of Section 2. I think the more important one, I guess we can debate what's more important, but one that's quite important is we know that Section 2 itself is incorporating essentially the ethos of those two pre-Bolden cases I mentioned, the Whitcomb v. Chavis case and the White v. Register case. In Whitcomb, the plaintiffs brought a racial vote dilution case. Those plaintiffs lost. In Register, the plaintiffs brought a racial vote dilution case and they won. The court applied the same rule in both cases. In fairness, the rule has always been understood to be a little bit cryptic, but as I argue in the article, we can actually glean more content from the analysis than I think some people have said. But the court applied the same rule in those cases. And an important plank of that rule was that no group, no racial or otherwise, has a constitutional right to proportionality in the sense you just mentioned. It is possible, for example, this was as the court explicated it, you might simply lose in a fair election, and in a fair election end up without proportionality. If the election is fair, and of course, fair can be disputed, one thing that these cases are trying to do, I argue, is articulate a vision of what normal politics are and define it in contrast to what the famous Senate report for Section 2 later calls racial politics. If the politics are racial politics and you are losing elections repeatedly, then we might have a problem. If we have normal politics, the mere fact that you don't have proportionality without more is not going to be a problem. So that's not something that the current court has made up. That is, that's in those pre-Bolden cases. And it's, I think it's fair to say, especially if you read the legislative history, which I've done for this article, that Congress was trying to embrace that aspect of the cases as well. So I think just as a matter of if you care about, and of course there is the textual proviso in Section 2, which arguably confirms what I think the context and history already suggests. That is that Section 2 is not creating a right to proportionality. There's some complications with that, and I won't get into that here. So if you do care about congressional intent, which I do think it's fair to say that one shouldn't interpret Section 2 in a way that would suggest that the mere absence of proportionality is a constitutional or, since we have a statute here, a statutory problem. So that's just as a matter of interpreting the statute. It also matters as a matter of the constitutional question, which the Supreme Court has injected into the case in its re-argument order. To the extent, and this is a point that was made ad nauseum in the debates over the amendment to Section 2 by Senator Orrin Hatch, who was the leading opponent of the amendment. To the extent that Section 2 is thought to essentially be saying, and it doesn't say this to be clear, to the extent that Section 2 is thought to essentially be saying, you have a statutory right as a racial group to controlling whatever percentage of the population you are of seats, that could raise problems under the colorblind approach to the Constitution. Why is that? Well, to say that your proportion of the population without more defines how much political power you should have would, arguably, under the development of the colorblind approach, be essentially making assumptions about several things, perhaps making assumptions about the prevalence of intentional discrimination's effects, perhaps simply making an assumption that race should be the defining feature for persons in a political system. So there are a variety of tenets of colorblindness that a kind of pure proportionality approach to Section 2 could risk running into. Now, fortunately for Section 2, it was not designed to create a right to proportionality. And as it's been interpreted, it has not created such a right. And scholars like Professor Nick Stephanopoulos have pointed out in a variety of places that in practice, there hasn't been a right to proportionality. And in fact, non-white groups in America don't have proportional representation in legislatures. So that's the long explanation for why proportionality could be a third rail. Now, it is relevant in the following sense. If you have the indicia of what I call, quoting the Senate report and some newspapers at the time, if you have indicia of racial politics, the lack of proportionality could be one piece of the puzzle, one piece of evidence that the effects of past or present intentional discrimination are at work, such that the repeated losses by a racial group's preferred candidate should be thought of as something other than normal politics and should be thought of as racial vote dilution that is banned by Section 2. So Section 2 is creating a very holistic and comprehensive approach to this problem. Because the big problem is in a majoritarian system, and this is obvious, but I'll say it, in a majoritarian system, numerical minorities lose. And this is a point that was made in Whitcomb and Register themselves. Our sort of default assumption is that a numerical majority is supposed to lose in a majoritarian two-party system. So what would we need to see to believe that what appears to be the normal operation of majoritarian democracy is not actually appropriate? And in particular, what would we need to see to believe that those losses are, quote, on account of race in the way that Section 2 is interested in? There are ways to detect that. That's the work, I argue, of the Jingles factors, which we've been talked about much, been going on pretty long with these answers, but that's the work of the Jingles factors that were developed in an important case called Thornburg v. Jingles. And I'll just say briefly that one of the contributions, I believe and hope, of the article and brief is pointing out the underappreciated way in which the factors that the Jingles case directs courts to look to in evaluating Section 2 cases ensures that Section 2 liability is only found when we have good reason to believe that the effects of past or present intentional discrimination are, in fact, the reason why a racial group is suffering repeated losses. In other words, those factors are working to identify situations where we aren't dealing with, quote unquote, normal politics. Sorry for the lengthy answers here, but
Can I ask you to talk with a little bit of further specificity about a dimension of your amicus brief, which is a very lucid, it's a very cogent and quite, I think, perceptive analysis here. But as you said, it's in response to the court having called for a re-argument, and with respect to a constitutional issue that was only showing up late in the briefs, the first round. And so, as you indicated, there's now this very overt hint that the court itself is ready to do potentially something dramatic that wasn't necessarily a central part of the original arguments here. Your brief seeks to respond to the potential constitutional problem here in three ways. I mean, you set up these three separate or three important arguments that to prevail on that side of the case, all three of them have to come your way. And I'm just wondering whether you have a sense of what's the hardest of those three dimensions.
Very good and interesting question. What's the hardest for me? No, I got to say, I just think I'm right. But what is the hardest? So I think one aspect of it that I certainly thought a lot about was the need to explain how and why the account of Section 2 that I am offering is not running into the quote unquote original sin problem. So this is kind of a manifestation of the way the court has talked about what is necessary to satisfy the remedial rationale. So after the student superior admissions case, the permissibility of states acting to remedy the effects of intentional discrimination, that is still permissible. But the court had, long before the student superior admissions case, cabined that rationale in some important ways. One important way, and this goes back to the controlling opinion of Justice Powell in the Bakke case, one important way that the court has cabined that rationale has been to say, well, you can't invoke generalized societal discrimination you can't say, well, there was discrimination in the past, and therefore we are relying on racial classifications. So my account is related, in part at least, to the effects of past intentional discrimination. Side note, I emphasize past or present when I talk about it because there could be present intentional discrimination, and that discrimination could have effects, but we'll put that to the side for a moment. To the extent that one is relying on past intentional discrimination's effects, how does one respond to the potential pushback? Well, why isn't this just generalized societal discrimination? I think there's a couple of points to be made there. The reason I still don't think this is, I think I have a good answer to it, is because Section 2 doesn't sort of stand in a vacuum. It's been implemented over time doctrinally, and it's been implemented by that Jingles case that I talked about, the Thornburg v. Jingles case. And so when you run through the three factors that Jingles sets out, just briefly, I'm going to paraphrase him a little bit, but briefly, the first factor of Jingles is that the plaintiffs have to show that an additional majority-minority district could be drawn in which a compact minority population exists. Now, another way to talk about that requirement is kind of to just say you need to have sufficient racially identifiable housing to satisfy Jingles 1. And another way to talk about that is to say you have to have sufficient housing segregation to satisfy Jingles 1. Now, housing segregation doesn't kind of pop out of nowhere. We have good reason to think we often are able to point to particular government sanctioned acts that are the cause of housing segregation. So to the extent, and it does require this, to the extent that Section 2 requires you to show housing segregation as part of Jingles 1, it is essentially, I argue in the article and the brief, it is essentially saying, please identify for us some indicia of intentional discrimination's effects persisting into the present. And that's just Jingles 1. Jingles 2 and 3, usually taken together and shorthanded as racially polarized voting, if you disaggregate them slightly, what Jingles 2 and 3 are requiring is that a block voting majority racial group is repeatedly voting against a politically cohesive block voting minority group and defeating that minority group's candidates. And so what is requiring, I describe in the piece, is essentially outcome determinative racial agonism. I'm not saying antagonism. I'm not necessarily characterizing the motivations of the groups, but the fact of the matter is that we have this opposition that is explained along racial lines, number one. And number two, it is explained along racial lines, we can see, because the two racial groups are politically cohesive. Now, political cohesion for an identifiable group is not something that's par for the course. You can't just assume that an identifiable group is going to be politically cohesive. As I point to in the article and the brief, there's several important groups in America that are identifiable, but which are not politically cohesive in the way, at least, that Jingles 2 and 3 would require. So, for example, there are those statistics that I identify from the most recent national elections, and this is a trend, actually, showing Latino voters decreasing in political cohesion. And historically, I mean, women are clearly an identifiable group, but their political cohesion is far, far less than the political cohesion historically of, for example, Black Americans, Black Americans. So again, why would this cohesion exist? I'm not saying this is conclusive, but there is reason to think, especially given the history of race in America, and in particular its connection to electoral politics. There is reason to think that political cohesion that is showing up in this outcome determinative oppositional way is traceable to the effects of intentional discrimination. And the last thing I'll say, I just want to reemphasize that these are just inferences. These are potential inferences. It's entirely appropriate, and in fact, it is permitted for defendants to undertake to rebut those inferences. It's totally fair, for example, for a defendant to say, well, sure, you've satisfied the Jingles factors, but look, there is already proportional representation. The court has long said that proportional, and I'm using proportional representation and proportionality interchangeably here, even though that's maybe not totally correct, but the court has long said that proportionality can be a defense, right? So there is this permission structure under which the state is permitted to rebut those inferences. And I think that's appropriate. It's appropriate, as I say in the article, for the state to offer good reasons to believe that the complained of losses are not really, quote, on account of race. The reason had to be good. The burden should be on the state if the Jingles factors are satisfied. But the fact that these inferences that I'm arguing Jingles creates are rebuttable is an additional reason to believe that when a plaintiff can run the Jingles gauntlet and survive an attempted rebuttal by the state, all of that should give us good reason to believe that the narrow set of cases where plaintiffs can do all of that really are cases where the effects of intentional discrimination are persisting into the present, so much so that a facially neutral electoral device like a districting map is in fact illegal under Section 2. So that's why I do think the original sin issue is one that has to be dealt with in a nuanced fashion, but I do believe that Jingles has, as it has developed, provided a pretty strong answer to that issue.
Well, and you've just described that in particular with respect to what is the first part of your brief, arguing that there is a compelling interest here for the state to have used race that would then allow it to survive the Shaw versus Reno challenge. But it also relates, I think, to the second point, the self-liquidating idea that you talk about. And I wanted to give you a minute to just share a little bit more about the importance of that argument, and particularly as a way of, in part, distinguishing what's happening with Section 2 here than from what might have been happening with the Section 5 issue in Shelby County and so on.
Great. Yeah, thanks for that. So you're absolutely right that the points I just made are essential part of the arguments I make about self-liquidation. So really briefly, self-liquidation is essentially the idea that Section 2 will activate less and less as the conditions for its activation decrease. And I guess that's sort of a tautology, as I just stated it. But the point is that those conditions are, in fact, the sort of conditions that decrease. In particular, as I just talked about, those jingles factors that I just mentioned, housing segregation and racially identifiable voting patterns, are the sort of facts about the world that change and can decrease over time. And as I point to in the article in the brief, have decreased over time in many places. Now, in fairness, there are some places where we do still have very stark racially polarized voting, for example. But in my view, that's kind of a feature, not a bug, of the account I'm offering. It's precisely because that kind of voting has decreased in many places that we should feel more comfortable in concluding that when it does exist and when plaintiffs are able to satisfy all the other difficult challenges that Section 2 doctrine requires of them, we should feel more comfortable in concluding that we really are dealing with the problem that Congress legitimately sought to solve. Why does self-liquidation matter? Why does it matter that Section 2 would activate less over time as the problem it targets is dealt with? It matters because, and this is a point that is central to the Students with Fair Admissions case as well as Shelby County. Students with Fair Admissions kind of is a maturation of some of the ideas that are expressed in Shelby County with respect to there needing to be a justification for using racial classifications that is not a justification with indefinite scope. So this is a point, for example, in the Students with Fair Admissions case that is brought up repeatedly in the opinion. The court has this punchy line, says no end is in sight for the justifications the universities were offering in the Students with Fair Admissions case. So people can argue about that or not, but it's important to see that self-liquidation starkly distinguishes Section 2's operation from a scenario in which no end is in sight. It's not just theoretical, although theory alone is a distinguishing point. As I point to, drawing on other people's work, empirical work, I mean. I'm not an empiricist, but I do rely on some of that work. As I point out, we have seen important decreases in the activation conditions for Section 2 over time. So both in theory and practice, the self-liquidation idea is a real one. And if it's real, then it's not fair to transport this idea of, well, no end is in sight. It's not fair to transport this idea that we see in Shelby County of, well, things have changed and Congress, your law, has not changed in response. We have the opposite situation. We have a law that, as designed and interpreted, is inherently changeable. So those are the ways, and by the way, this is a point that is quite important to Justice Kavanaugh. It's a point that he has raised at both of the oral arguments in the Callais case, this idea of a temporal limit on some of Section 2's activity. Now, to be clear, Section 2 is a permanent statute in the following sense. It's always going to say, don't dilute the vote on account of race. I don't think that is the command that needs to, quote unquote, expire on this view. The thing that needs to have some sort of time limit on it, and the thing that in fact does have some sort of time limit on it, is the set of cases in which Section 2 ends up requiring a state to consider race in order to adopt a plan for elections that the state would rather not adopt. That set of cases is going to decrease as a result of self-liquidation, as a result of the activation conditions for Section 2 decreasing. So I hope that was responsive to your question. I think the question was about self-liquidation, yeah.
Thanks.
Well, unfortunately, we're out of time. I'd like to thank Kerrel for a fascinating discussion, and we look forward to having you in the program again in the future. To our listeners, please like and subscribe to Law and Democracy and stay on the lookout for our next episode on YouTube and Apple.